Attorney Rekha Ramjit, who is the leader of the ILP, came here as an attorney, spoke as an attorney on a matter that affects all of us, crime. How we look at the problems, the hurdles, how we surmount them. And that's why I asked her back this week. Thank you so much for taking the time to come down.
And it is my pleasure to be here.
It is truly a pleasure to have you here without question. The minister continues to talk about, this is the Minister of Legal Affairs, the Attorney General, I'm sorry, correction there, because the murder rate continues unabated, and though we are told crime in general is down, the citizenry does not feel so. They are many years in the making, is the general feeling. And only a collective, open process can ensure that we have a sustained approach to correcting the problems we have. It is against that backdrop that I raised the fact that it costs the state $50 million a month to maintain, 2,235 odd remand prisoners. The Attorney General said that preliminary inquiries is one, removal of preliminary inquiries will be one area to correct this. I remember the last time you were here, you said, not so fast, I'm not too sure that is going to yield the results. Remind us and refresh us, please.
Right, I'm saying preliminary inquiry is really that aspect of a trial process that starts in the magistrate's court for indictable matters, being the more serious matters. Then, if a case is made out, and it's called a prima facie case, the legal term is made out, the person is then committed to stand the trial before a judge and jury. So you have two things linked there, because there's also the suggestion that jury trials should be abolished. But that's another topic. With regard to the preliminary inquiry, the basis that the AG is using, he's saying that if you remove preliminary inquiries, it will shorten the process and then therefore deal with the backlog that we have in the entire system. I am not in agreement with that as a method to deal with the backlog in the system, because magistrates court is separate to high court, where you have judge and jury. So all you're doing is taking it from one road and putting it onto the other road. So by transferring the traffic from one street to another street without clearing a process at the roundabout, you're going to have the same traffic.
That is very clear to me. Among the many things that I smile when I see it unfolding, because you mentioned part of the problem in clearing the backlog is equipping and training, retraining also our police service, getting the right pathologists in place, getting the DPP up to scratch. And the DPP is my area there, because they've been added 35 attorneys. How encouraged are you at this 35 attorneys being added to the DPP's office?
Right. That is one element that is required, but now we need physical courts to place those DPP attorneys. So it's a holistic approach to it. But if I were just to go back to the PI, what the PI does is, now magistrates court is less expensive than high court to run. Yes? So if you go to the magistrates court and a matter is dismissed based on a no case submission, it doesn't ever get to the high court. The assumption, or it is implied by the AG, that every matter that goes on a PI before the magistrate court ends up in high court. That is not so at all. I am practicing in the criminal arena, and my own success rate at having no case submission upheld is about 40%. So that if I were to have 10 preliminary inquiries, 4 of those will not reach high court and will not engage the resources of judge, prosecutor, defense attorneys, police officers, prison officers, etc. And as a matter of fact, the jail will be cleared up earlier. Let us take capital matters. That is a non-bailable offense. So it takes about 3 years to get it done in the magistrate's court, another 5 to 8 years in the high court. If that matter is dealt with in the preliminary inquiry stage and is dismissed, then you have 40% of the persons not having to go and stay in prison and all the attendant costs of that. Because it's not only staying in prison and it costing $25,000. Every time you bring them down before the judge, it costs money to transport them. It costs money to have police officers there, prison officers there, and everything else that goes with it. So that unless you can show me a way to deal with the log jam, as I call it, in the high court, then it makes no sense removing it from you are transferring the problem from one court to another court. There is another aspect of it that John Public probably doesn't realize.
Please.
The cost of doing a matter in the magistrate court is much less than doing a matter in the high court. Yes? So that you are asking the family of somebody who has been charged, and I keep reminding Trinidad and Tobago that a person is innocent until found guilty. right? So you have somebody in the magistrate court. It's going to cost less to do a PI, either if you are privately retained or even from legal aid. Legal aid recognizes that as well. And so you are asking persons who probably have a good case for a dismissal to wait until you go to high court, or remove that completely, and it will cost much more to have the matter done in high court. Yes, the criminal procedure and all the changes suggest that there's going to be a system to deal with the no case submission in the high court. That means you have to put into there probably a master or some lower level than a judge to deal with the same function that the magistrate would have had to deal with. That is to look at all the evidence and say whether or not a prima facie case is moved. So I am just seeing a transference from one court to another, and that to me is not the way to go. You cannot remove the preliminary inquiry and not understand that you are going to have people stay in the prison for a longer period of time, when in fact their matter may have been dismissed after 2 or 3 years.
The voice you're hearing is that of attorney Rekha Ramjit, who is, I guess, a defense attorney, and she's talking about taking out one basket into the other one. Let me see if you're encouraged by this, attorney Ramjit, and this is the area of cashable bail. Do you find that an encouraging initiative towards reducing remandees?
Yes, it is, but we do practice that. That is on the books. It's not done as often as it maybe should. But you see, let us expand that bail issue, right? Because we have a white elephant in the room. And that is, it is against the law for people to pay bailers. That's against the law. You see, like in other jurisdictions where they have professional bailers, we don't have that.
Right.
It must be a relative or a friend or a good Samaritan who says, okay, I'm going to put up my land worth $1 million for your $250,000.
Just detail for our listeners so they are very clear, because yes, you're right, and it is an area of ignorance. When folks hear of a bail bondsman and so on, where you pay a bondsman to get you out of jail.
That's
Explain that to our listeners, please, so they understand what obtains in the United States, for instance, but does not obtain here.
Right, precisely that. You pay a licensed bail bondsman to take your bail, and then he's responsible for making sure you get to court. In Trinidad and Tobago, we don't have that. So that what we have is relatives or friends or good Samaritan who's going to take your bail. But that is only in theory, because every judge, every magistrate, everybody knows that they pay bails to get their bail done. They are professional bailers who are doing something illegal, and that is and that has been accepted. So we need to shift. We need to accept that people are not going to be putting up their land and their money for somebody who's going to be in jail 12 and 15 years. More for an indictable offense. And then if he doesn't show up, you forfeit.
So take it out of the shadows. Let us just deal with real bail bondsmen. Put that in place, and then you see this as encouraging plea bargaining, another area.
Well,
that, again, I'm asking all these questions en route towards reducing the number of remandees we have.
Right. So no, there's very little connection between the two. Little connection between the two. I'm just dealing with one aspect of our justice system that is archaic and needs to be looked at. Plea bargaining. We do have a plea bargaining act. And I'm going to stick my neck out here and say it is not being used sufficiently. And it is not being used sufficiently because our initial original system of justice was adversarial. Is adversarial. It's them against us. It's the prosecution against the defense, and both sides fighting to see who could win. It's about numbers, and it's about winning. It has ceased to be about the dispensation of justice. What we need to have is a change with regard to the approach that is adopted by both the DPP and the defense attorneys on both sides. That says, let us sit down and talk more about how we can make use of the Plea Bargaining Act to reduce the number of people who are sitting in there, either encouraged by their own defense attorneys or either because they have been refused a discussion with regard to plea bargaining.
Am I clear in understanding that you're saying we are looking, if I extrapolate correctly, we are looking at the pursuit of justice and not racking up numbers of victory?
That's right. And that's precisely what it is. prosecution wants to win the case. It goes to your credit. Defense want to win the case. And so where there might be a possibility, let me just give you a couple of examples. In recent times, what I have done. Persons are sitting in remand for in excess of the time, that the maximum time they would have had to serve had they pleaded guilty. I mean, where does that take us? It takes us nowhere. There are situations where when you read the facts, you may suggest to your client as a defense attorney, well, listen, based on what I have here, the suggestion is that you might want to consider plea bargain. Now, in recent time, and I take my hat off to Justice Lucky, because she had started really active work in the area of what we call, it's discussion really, MSI, right? It's a sentencing, maximum sentencing indication. And what it is we say, listen, we are not pleading guilty. But here's what. If my client was to plead guilty, what would be your maximum sentence given the aggravating factors and the mitigating factors of the circumstances? So that is done. Attorney then, and you take into consideration, of course, that if I plead guilty, then I get 30%, 1/3 or for 25 or whatever the decision is. It is not fixed. More often than not, it is 1/3 of the sentence. Then I get time off for the time spent. And then where does that take me? And then the accused has an opportunity to say, well, you see, that makes sense to me. Added, of course, to that is the fact that you look at the evidence. What I say to my clients, and I've done quite a few of these MSI, what I say to my clients, if you haven't done this and if you are innocent, do not plead guilty. Because it goes against your character.
The dangerous thing about having an interview with an attorney is because they read your eyes. That is exactly where I was going. The whole question of abuse by by attorneys who recommend to their clients to plead, as a matter of fact, of getting rid of the case and chalking up another victory.
Right. What that also does is,
or another settlement.
Right. If you have evidence 50-50, then what happens that case? And this is what the public are annoyed about most of the times with the results of the justice system, is that based on the evidence, there may be a 50-50 chance that he would be found guilty or not guilty. And then you start looking at all the technicalities, etc., right, which requires a lot of resources. Whereas with the MSI, based on the evidence, I say, listen, I am willing to listen to what you have to say. If it is too harsh, in my opinion, as the accused, then I will take my chances with a trial and convincing the jury that they do have sufficient evidence for you to find me guilty or to raise some doubt in your mind. So that is an area that will assist with reducing the amount of remandees if we were to actively pursue it. But it is my humble opinion, and I have operated in many of the courts in San Fernando, in all of the courts in San Fernando and in Tobago. I have not really operated in Port of Spain. I do not find that there is an attitudinal change by either the prosecution or the defense with regard to that issue. You need to have that, because you cannot do it unless you remove the adversarial element. Now, there is an attempt to do it by introducing what is called the criminal procedure rules, which requires you to be more open with your information. That, to me, is insufficient. We must, and whether that requires us to retrain our prosecutors or retrain our judges or retrain our defense attorneys and say to them, listen, every 3 years you must come to a 1 week refresher course to tell you what the new law is, to tell you what the trends are all over the world, to tell you how we should approach this non-adversarial track that we want to get on to deal with it. And I feel if we have that, then more advantage can be taken of the plea bargaining act.
Let's be very clear. There is consensus among my guest, Attorney Rekha Ramjit, and the Attorney General. What he actually said is that we've got to have a more effective plea bargaining system, which is consistent with what you're saying. It exists, but we've got to find a more consistent way of having it
But Attorney General must understand that those words have to be supported by action, and that action must make sure that the Trinidad and Tobago offers to the judicial system, the judiciary, and all its various elements, the necessary retraining that we need.
One of your passions that is oft discussed elsewhere, and I know specifically in New York for the past 20 years while there we've been working on this whole question of legal aid. I know that's one of your passions. And when you look at the cost of $25,000 average per month to keep somebody in remand, and you think of the cost of setting up a fully functional legal aid system where attorneys are paid something that is worth the while for them to make themselves amenable to working in that area and stuff like that. Would you say that the woeful state of legal aid in this country is best serves the country if it is brought up to speed, because the money you spend on keeping them in remand is in fact doing two things. One, furnishing the legal aid society, and then making accessible to all justice in a speedy manner.
Absolutely. And then I just want to add that in addition to that $25,000 a month for each person, in addition to that, you must not forget that keeping somebody in prison and bringing them down once a month or so is an additional cost. Don't forget that at all, because that to me is an issue that needs to be dealt with.
Yes.
And it is an expensive issue. I had said on the last occasion I was here that if that was to be removed, you have monies to do a lot of other things, right?
That's right.
So the legal aid system, what is happening now, and the legal aid system, and I'm sticking my neck out here to say that the legal aid system is crumbling because of the poor remuneration to defense attorneys who have had in excess of 10 years practice before the bar. You find that a matter may take you 2 or 3 months, and the remuneration does not in any way compensate for that the matter is being sent back. And when a matter is being sent back, let us take a capital matter. When it is sent back, you need to find 2 attorneys. You need to find advocate and instructing attorneys. You need for them now to bring themselves up to speed on what is in the file, and that takes some doing because it is a capital matter. It's extremely demanding. You need to look at all the law. You need to do all your interviews with your accused and their witnesses, if there are any, so that it takes another 6 or 8 months before somebody can be court ready for a trial. Writing all the letters, etc. So what is the cost? The cost to not having an efficient and an effective legal aid system is that person remains in remand for a much longer period of time.
That we pay for.
Right. Translate that into dollars and cents. And don't forget the transportation, because transportation involves not only paying for the transportation, but prison officers. Prison officers, when they get to court, they have to be dealt with and processed downstairs. Then it's the court's time, magistrate's time. Then it is prosecutor's time, court staff time, and defense attorney's time. So we haven't begun to even look at that. And what do we need for an effective legal aid system? We need actually for us to appraise whether or not what we have on the books and as far as the law is concerned, what the remuneration is for practicing attorneys. And not only that, we suffer from something else that I am going to say annoys the hell out of a lot of defense attorneys, and that is there is no standard as between the judges as to what you get. So that if the range is between 20,000 and 30,000 for a capital matter, one judge may give you 20,000. Another judge may give you 30,000. Right? And you're never really sure what the criteria is, right? I can talk from personal experience. And
this is the awarding of costs you're talking about.
Yes, legal costs. I'm going to talk from personal experience. And again, I stick in my neck out, but somebody has to say it. There was a instance where my client was charged with murder after some long negotiations and attending court for about 3 years. We finally got an agreement by the DPP for him to plead guilty to manslaughter. Yes? So pleading guilty to manslaughter meant it was a lesser charge, penalty shorter. He got his 1/3 off. He got his time for he was out in 2 months. Right? Served his time based on the evidence. Not a women fancy.
Right.
On the evidence, he satisfied manslaughter. Judge paid me $6,500. I sent it back to legal aid and I said, this cannot be right. Legal aid asked the judge, was there an error? Because they were amazed at that as well. No, there was no error. So unless you have, no, there was no error. At that point, I'd said, I'm going to send back all these briefs. It's not making any sense. Of course, we had some discussions, and I'm still doing a lot of briefs to them. But that tells you that there is no standardization. As amongst the judges, you must have some standardization.
Well, without question, because it becomes untenable for you to do this and receive your transportation costs, and even that may be in question, because that's just about as much as you will get done with $6,500.
Well, no, I wouldn't even get that, because it was several years, 3 or 4 years. But the point is, if you cannot have a standardization, because really everybody is subjective. One judge might think, oh, this is a simple matter, etc. Then let us do it according to the amount of work that you do in a particular matter. And the judge can control that. He can say, well, you see, in this matter, we really only had 10 hours of actual work, as opposed to coming for 20 days, right? Let's not go with days. Let us go with the amount of work, effective work done in the court. And I'm not even talking about preparatory work before you get into the court. I'm talking about court time work.
Got you.
Base it on court time work at a particular rate, so that everybody knows where we're coming from.
That is a very important point that you make there, Attorney Ramjit. The Legal Affairs Department may want to take note of that, how many hours you did, and maybe some of those $1 million payments we did. That's another conversation. Oh, I'm sorry. Yeah, okay.
That's a conversation I'd like to get into. I'd love to get into that particular conversation.
Yeah, we will get into that at some point later on. We're continuing with Attorney Rekha Ramjit, the leader of the ILP in her capacity as an attorney.
Can I just say one thing? I had talked on the last occasion of an adjournment court. Yes? Okay. In addition to that, there can be no reason why we cannot also have a guilty plea court in the prison. Because I'll tell you why. A lot of times, for minor matters, summary offenses, do not for one moment believe that all the people in prison on remand is because of indictable matters. There are summary matters, and they say, I'm not guilty or whatever. If you have an effective plea bargaining system and unit, right, and MSIs, then there is no reason, because a guilty plea does not require a jury. The sentencing does not require a jury, does not require all the paraphernalia that you have. And all it is as between defense counsel, prosecutor, magistrate, or judge, as the case may be, let us say magistrate, is some discussion. And really, the submissions on sentencing are made by defense attorney and prosecution, and judge then decides on the sentencing. Because remember, the jury's function is finished when they find him guilty or not guilty. Right? So why can't you have a guilty plea court set up specifically to take that out of the hands of a judge or a magistrate who is doing an actual matter?
A guilty plea court, that working in tandem with the adjournment court. Remind our listeners exactly what that was. You did discuss it the last time, setting it up in prisons.
Right. In prison where there are several matters, especially indictable matters, and sometimes in summary matters where information or documents or what you require to go forward, for example, forensic reports, etc., are not available, and you cannot go forward. So all you have to have an adjournment, right? So that is done until such time. So, for example, if I may just remind your listening public that it takes 18 months to get a forensic report on weed-like substance, plant-like substance. It takes 2 years for illegal ammunitions, etc. And sometimes it takes a little while for us to get the post-mortem report, etc. Right? In addition to which, we are going the way, in a lot of cases, of paper committal. It takes some time for state to have all the statements ready. I have done capital matters with 47 witnesses. So you might have 25 witnesses, right? 30 witnesses. It takes some time, and that is to be expected, for state to have all the statements prepared and sworn to, etc. And it takes some time to file that and serve it on a defense attorney, who may then say, I only wish to cross-examine 5 people, but I wish to object to hearsay evidence in 5 more. All of that is done before you start the trial. All of that could be done whilst you have the adjournment.
The adjournment court,
So
yes.
when you start bringing the gentleman or the woman down to court, it is to hear evidence and to make your submission.
It is truly good to have you here because you identify some meaningful areas. Adjournment court, a guilty plea court, the whole question of that thing of transporting prisoners and the industry that's involved there, which is the industry of transportation, because that is an industry. A lot of people eating a big food in that area.
So I'm not being political, but I'm saying every single government to date has catered to the whims and fancies of big business who capitalize on this. And now they can't do anything about it because they would be probably backtracking on an agreement. And I'm not saying this about this government. I'm saying this generally
Yes.
because there can be no logical reason why two practicing attorneys as Attorney General, Anand Ramlogan and Faris Alwari, does not understand that concept of removing that heavy transportation cost with regard to the criminal matter. They didn't practice in the criminal arena, but they are brilliant men.
Yes, and it goes to what you said before. They may see the wisdom in it, but sometimes when you've got elements that you have to fight who are enshrined, it takes a serious political will to break down the barriers. That is a whole different conversation. Attorney General Francis Arari said that 42% of the remand population were there on murder charges, 11% on drug possession, 7% for sexual offenses, 12% for lesser offenses, including child maintenance and traffic offenses. When you look at this list, you understand why we have spent the time we did when the attorney was here last time, and we are spending it here again. Faris Awari, in case I erred and said Francis, it is necessary for us to cut down that remand population and remove all the hurdles in the way of doing that. That is only as far as remand is concerned. You wanted to make a point because I want to go to the GP after, but I'll wait for this.
Right. 42% capital matters. That's what the AG said, right?
Yes.
Right. I am shocked at that, but I'm glad that he has brought that to the fore. That brings me to my point about dealing properly with plea bargaining and reducing to lesser counts, either felony murder or manslaughter. Because if 42% of your population is for capital matters, remember that is an unbailable offense.
Yes.
And it's taken, I have a matter in another court, I'm going to just briefly say, 7.5 years and we haven't started the PI properly as yet. I'm not going to go into the details. But if a capital matter takes anywhere between 10 and 15 years. So you have, from the date that you have held him or her, charged him, to the date that he can be either transferred to serve a term or on death sentence or go home back, 12 to 15 years. That's what you maintaining him there for. That's what you maintaining him there for. First of all, so why do you want to deal away with the PI where, let us bring it down to even 25% success rate at the PI stage of a no-case submission. Let's bring it down to that, right? So that's 10%. Immediately removed after 2 or 3 years. Let's work the maths on it. Sit down and logically think about it. If your major percentage, almost half of your population, is on capital matter, I'm not even going to go to what that says about our society. I'm not going to go to that. But let's talk about the cost. And the more reason, why are they still there? They are still there because legal aid cannot handle, under its present situation, with regard to fees and with regard to available attorneys, handle the level of capital matters that they have to deal with. A capital matter takes at least a month to 2 months. You need to have attorneys with experience. You need to have 2 attorneys. And if you are not paying me properly, then what is going to encourage me to
take the brief?
Especially when I sit back and I realize you're paying millions of dollars in civil matters where people's liberty is not at stake.
And you see, that's why when you said that is a matter that you would like to enter into that discussion, if a pre-protocol letter is going to bring you that much money, why you want to take the responsibility of a capital offense?
Yeah, where you're not even going to get $25,000 that will take you 2 or 3 months. It is, I am in practice 12 years, right? Anybody can go to the Legal Professional Act and see that my rate per hour is supposed to be $2,500 per hour. I spent 2 months in court and you pay me $20,000. And I dedicate myself entirely to that matter. I'm not saying that you should pay $2,500. But I'm saying it should be a reasonable percentage of that if you want to engage the talent that we have in Trinidad and Tobago to deal with the backlog that we have.
Guidelines for cost is what is imperative here.
That's right.
Attorney Rekha Ramjit, we continue our talk here. I just want to go leave remand. We have spent some time there, but something that has stuck in my craw, and from your perspective, a member of the Law Association, etc., and a practicing attorney, in the case of not remand, but those in jail, somebody is convicted already. The case goes to the Privy Council. Of course, we know you must have money for that. And, of course, that takes another 5 years. In case a person's got to be executed, you got to do it within 5 years. You don't do it within 5 years, you can't do it because it's cruel and unusual. So we spend a lot of time with the Privy Council. But there is a CCJ, a Caribbean Court of Justice. What is the holdback in your view as to why we have not, one, accepted it in Trinidad and Tobago, and what role you think they will play in speeding up appeals that can help with the problem we have in our penitentiaries right now?
Okay. First of all, I'm not going to give my personal opinion on whether I believe the CCJ, we should give up the Privy Council or not. I've experienced the Privy Council. I've done a matter where I was advocate attorney in Privy Council. But generally, when you talk to attorneys, they do not have the level of trust. They do not have the level of trust in the judges. I'll tell you something. In this Caribbean country, and a lot of other Caribbean countries, whether there is evidence or not of that, there is the feeling, yes, that even our judges can be subject to corruption and to partisan behavior.
Is that a bit insulting, you think, for some of the eminent jurists we have in the Caribbean, that feeling is shared?
I'm not dealing with whether it's insulting to them or not. I'm dealing with what John Public believes.
John Public, not the attorneys, but John Public.
Well, attorneys and John Public. We form part of the public.
Yeah, understood. I'm trying to differentiate between who holds that view of the eminent jurists that are coming out of the region. It's something that I've heard repeated many times.
Right. And I want to say that people generally feel, if you talk to the man in the street, let me restrict myself to Trinidad and Tobago. Talk to the man in the street and ask them if they feel that judges are fair. Ask them if they feel that judges are not influenced by politics.
As in everything else, it depends on who you're speaking of and what side of the aisle they are.
Right. But ask them whether it is they believe. So we have a perception that all our systems and all our institutions have become corrupt. And the last one that has to happen in is the judiciary. So that John Public is not convinced that the judiciary is absolutely independent. I will give you a case. The details are a bit hazy, but I recall that there was a matter in 2014 or 2015 when Anand Ram Logan was the AG, where there was an African prisoner, right, who was kept here because he was here illegally. Judge Court of Appeals sat 3 o'clock in the morning and have him removed. You understand? And there are certain other matters that will not get that kind of attention that are more important to this country. So the perception was, I'm not stating my opinion, but the perception was that influence could be had to have a plane on standby, etc., for that sort of thing. That is the perception. Now, if you have that perception, then obviously the headquarters for CCJ is in Trinidad, right? And you will have our judges going there. We must be absolutely certain that the judges that go there are who we feel can be absolutely independent. I don't think that Trinidad and Tobago, John Public, believes that at this point in time. They believe the Englishman or whoever sits in House of Lords are independent because they are not influenced by our politics, etc., and they are not influenced by the cultural nuances
There are,
of Trinidad.
there are two aspects to this, Attorney Rekha Ramjit, that I need to press home here. One, I hear Attorney Ramjit, I hear attorney this or that, and I start discriminating in my mind and remove them from John Public, because I say to myself, the learning is a little more different, the exposure is a little higher, the ability to discriminate between what is in the public arena as mauvais or perception is different with an attorney. But what I'm hearing here, tell me if I'm hearing incorrectly, is that those in the legal profession are suspicious and saying that folks in the CCJ can be made or can be corrupt.
Right. So what I'm saying is, in the legal profession, I'm going to answer your question. In the legal profession, there are those who believe that the judges who are appointed here in Trinidad and Tobago, it's not always done on merit, right? There are other considerations. And that it is the judges from here who will form part of the CCJ at some point in time. And that is, I'm not commenting on any other areas. I'm not commenting on anybody who's thinking. I'm talking about our own judicial system.
And there's one other area I want to go with that. When you
but
say
can
that
I just say
yes,
that in recent times, the confidence, the high level of confidence and trust that the public has in the judiciary is being eroded. And you hear that on the streets all the time.
Isn't a contributor to that erosion when we say that the CCJ, which is supposed to represent the highest level of the profession, they themselves are amenable to manipulation? Is that not a contributing factor to that erosion in a public institution?
I'm not understanding. Are you saying if the judiciary here, if we say that?
I'm saying yes. If people are saying that there is no, that they can be made corrupt, that is the high level of those who sit on the CCJ, isn't that contributing to the perception that nothing is sacred? We know nothing is totally. But it
is a fear, and it may be a fear that is not based on any particular fact or any set of facts, but it is a fear that Trinidad and Tobago suffers from. And I'm just looking at the streamlining of our judges into the CCJ. I'm not talking about the other countries. They will deal with their own issues. But in Trinidad and Tobago, I think I think we have to accept that there is, that goes hand in hand with the drop in confidence in the police service, for example. These are all institutions that's supposed to protect and serve to serve the interest of justice. And there has been in recent time a drop in the, in that level of confidence, trust and confidence in the judiciary.
So you, from what I am gathering here, you are not very optimistic, I'm asking, that the CCJ will in fact be adopted by Trinidad and Tobago in the short term?
I think what it needs to be done, this is one of those situations where this country should adopt the approach of a referendum. Because, take me for example, I am not open to everybody's opinion on this. I am open to a limited circle of opinion. So that I think that this is a situation, because really, if we join the CCJ, we're talking about justice for the public. And therefore, it is one that we should bring to the public. Let the various, stakeholders present their arguments to and from.
I guess that is the most democratic way to do it, yes.
But we must give John Public the opportunity to say yes to the CCJ or no to the CCJ. We must give them that opportunity. We have always held the Privy Council as our last court, right, for justice, and we have to accept the rule. If we want to remove that, then let John Public do it, because we are not doing that for the attorneys and for the judges and for the politicians. We're doing it for 1.3 million people who want to have access to justice that they have trusted.
The leader of the ILP and attorney Rekha Ramjit is my guest here. In thanking you for being here, I cannot have you go without saying there are so many aspects of this, and every time I get you here, you raise other areas that bear clarity or beg your expertise. So don't be shy if you hear another tap coming from me. I do want to ask you about this idea in the last 2 minutes we have: ankle bracelets and video conferencing of in trials. How do you feel about that?
We already start practicing video conferencing, and on the last occasion I said to do adjournments, etc. And we do have video conference in the civil arena and family court. We need to transfer it now to the criminal arena, although it is available in Tobago in the magistrate's court. But again, to me, there will be little requirement for video conference in the criminal courts, especially in the magistrate's court, if you have adjournment court housed in the remand yard. Yes? Ankle bracelets?
Ankle
right,
bracelets,
ankle
yes.
bracelets. Yes, I agree with that, and I want to add one more to it.
Please.
Every police officer should have
Body
camera, because a lot of times we get into court and the case fails or goes forward, and the accused position is always they beat me, they do this, inducements, whatever.
Coercion, yes.
And then the judge has to decide who to believe. How can you decide who to believe?
So the body cams would go a long way towards removing
Body cams
that problem.
and every single confession statement should be taken on video.
Interrogation room, yes.
Right, because the history of the world is replete with situations where people have confessed to crimes that they later prove they're innocent of. And the reason for that is you relying on he say and she say. He say and them say. And you're asking a judge who's not there at all to make a determination on who to believe. And sometimes the policemen are so well versed in how they present. You can't really pass that hammer.
I hear what you're saying.
So those three things are necessary.
I hear you. Attorney Rekha Ramjit, again, so much. I mean, you know I appreciate this greatly. It's really good to have you here again.
And
reminding our listeners that our conversation here, like the first time the attorney was here, is available on our YouTube. Go up there and pull it down. You will find it instructive. Then, as a repeat of what took place here this morning, will be very useful to you once we put it up, and we'll be doing that by Monday evening. Thank you so much for taking the time.
It's my pleasure.
You have yourself a wonderful day. Thank you so much. See you soon. That is good. I like that.